Considering the time constraint, I am going to give an overview of enforcement of IP rights. I am limiting myself to patents. I will not trouble you with trademark infringement, copyright infringement, design infringement cases, or common law like law of passing off. You people will be just out of your seats and run away. I will not trouble you with this thing. So let's start with the what happens when you get a patent with the Indian perspective and how the courts have interpreted the patent claims. That will give you a lot of insight what to do, what not to do. So when I'm starting as a researcher, I should not be aware about what are the legal strategies or legal ways of protecting your patented invention, but I should be aware what will happen to my patent if it goes to the court of law. To that extent, we will just touch upon this particular subject today. As we have seen, grant of a patent. Once your patent is granted, in that stage, you are having the certificate of that grant. Your patent is granted. You will be able to sue others, whosoever is manufacturing, using, offering for sale, or importing that particular product without your consent. Under the patent regime, there is no provision for, unlike Copyright Act, there is no provision for filing a criminal complaint. You have to go to the civil court and ask for the remedies under the civil. The recognition and enforcement of patent rights in India is principally governed by the Patents Act 1970 and the rules issued. So what is the statutory law? As I said, the right has to be there so that there has to be a remedy. Whenever there is a right, there is a remedy. Grant of a patent gives you the right, the remedy lies in the civil court. How the civil courts have interpreted, apart from that civil court remedy, we have a custom enforcement of intellectual property rights, including patents, is governed by the Intellectual Property Rights Imported Goods Enforcement Rules 2007. Right holders can notify with the custom authorities of the goods allegedly infringing their patent rights. On the basis of such information, custom authorities can detain and seize the goods in accordance with the applicable procedure. So whenever you have a patent, you can go under these rules, register yourself and say that importation is happening from X country, Y country into this country, and you stop that at the border. You don't allow them to enter India. So the custom officer stops it, informs you, you are then told, go to the civil court, take an injunction order so that custom officer will detain it. And you get that breathing period of 14 days or 21 days as per the rules. Otherwise, if these products come in India and get sold, distributed through the retail chain, it is not possible for you to go behind everybody and get hold of that particular. So these are the strategies used by the patent holders to stop someone entering India. Especially as you said, the country, we should not use that name again and again in the online presentation. Court decisions are relevant source of patent law in India. Indian courts also rely on the decisions of both European and US courts as source of patent law. In the last few years, Indian courts have adjudicated on a number of substantive patent law issues, including infringement. Multiple infringement suits have been filed and injunctions or stay orders have been granted in favor of the patentee, who is plaintiff normally. So the courts have started recognizing the patent, as I said in the first session. Courts have started recognizing the patent rights. They have started understanding the patent right. They have started analyzing it. The system is in place for appointment of experts whenever it is needed. The experts committees are already in place. So don't think that your patent, even if it is granted, is unenforceable. That's a myth. We have a robust patent system wherein your granted patent will immediately fetch you a injunction order in your favor against the person who is infringing. Patentability. on the patentability up to Supreme Court, whatever we have discussed in the morning, novelty, inventive step, industrial applicability, as well as what is falling under Section 3 of the Patents Act, everything is now analyzed and the Supreme Court has laid down the law on it. So this is one of the source of when you are considering particular patent and patentability, we tell the client, look, this is not patentable because this judgment says so. This is not patentable because this is patentable because now this judgment says so. So to convince the officers who are at the patent office, we have something coming directly from the Supreme Court. So things have changed a lot in last 20 years. That's what I want to say. Like new use of a known thing in India has been held not patentable because of Novartis case. You must have read about Novartis case a lot about in last few years. Then fair and reasonable and non-discriminatory licensing.
Please explain that case. What is this?
I'll explain this particular thing in another case which I handled in Supreme Court, which is the slide, that order is there in front of. I'll explain how it works. Fair, reasonable and non-discriminatory licensing. I don't like to say anything about the case which I have not handled. Will be, and tomorrow I don't know whether I'll be relying upon it or not in the case. So, the stance that I have taken, I will not change. Otherwise, doctrine of estoppel will lie against me. Fair, reasonable and non-discriminatory licensing. We all know the what we call it as QWERTY keyboard, right? QWERTY keyboard. So that's one of the fantastic example of friend, wherein that technology, without that keyboard, nothing can work. So the court said, yes, grant him a royalty because everybody is required to use it. No phone will work. Classic case of fair, reasonable and non-discriminatory licensing. Licensing is compulsory. You have to give license. We will give you royalty. The court has derived a formula in that case. What should be the licensing amount in the interest of industry at large? Otherwise, only one will be manufacturing. He will charge heavy for that particular phone, and others will be deprived of it, and public at large will also be deprived of cheaper phones. So in this case, the court has come to the rescue of the public at large, granted the licenses to manufacture, and at the same time they have taken care of the original person who has created that particular invention. Permissibility of exports under the Indian Bolar exemption. As I said, something which is done by you for research and development, you have exported that particular thing, that is amounting to exemption. It is not infringement under the. We will just go to this particular slide because I have separate slide for this. Grant of a patent for computer programs is decided in Farid Allani versus Union of India, and now we have a computer related patent rules in place because of this judgment. This judgment has analyzed per se word in the computer 3K and said, if it is giving technical effect and technical advancement, if the technical effect is there, it is per se. If there is any technical advancement which is not within the meaning of per se, it is definitely patentable. Subsequent to that, there are complete rules which govern the computer related invention, and whether computer related inventions falling within that category, they will be granted patents. So this is a development. This is also one of the, we have just gone through it. This is one of the source of law which courts recognize. And having this slide because courts recognize these treaties. So in the priority, national statutory law will always prevail over the judicial decisions and international treaties. So one has to actually look into Patents Act 1970 when we are thinking about the patenting in India. When we are thinking about patenting in United States, we have to think about the local law in United States. In UK, that's why I said national phase entry is the most important entry in the TRIPS as well as this PCT application, because you have to analyze what is there in the local law. The provisions are made in this fashion that the United States will recognize their own law more than the international treaties. Similarly, we do. Patent enforcement. Under the Patents Act 1970, the district court is the first instance court for the patent infringement actions. If the defendant seeks to challenge the validity of the patent during an infringement action, the action must be transferred to the High Court. So in a case where you sue someone and defendant comes and says that, oh, your patent is not valid, it shouldn't have been granted at the first instance, then the district court doesn't have the power to decide that issue. It has to be transferred to the High Court. However, the High Court of Delhi, Bombay, Kolkata and Madras have original jurisdiction, and you can directly file the suit in those High Courts directly. The Commercial Court and the Commercial Division and Commercial Appellate Division of the High Courts Act recently enacted, and what are the changes that it has brought to the litigation, which we have to consider in the next slide, coming slides. The overall concept is litigation means tarikh pe tarikh. Litigation means date after date. Nothing will happen in the court of law. These changes in the law, that is Commercial Courts Act, then the rules specifically dealing with the patents and commercial disputes, have made a tremendous effort in have brought in this tremendous change in the overall litigation timetable, and it is definitely working. We have a system which will enable you to get the reliefs at the first instance itself. How? The language of the proceeding normally in courts is English, but there are certain courts wherein you can argue it in Hindi as well as other languages. The first step in the assessment of patent infringement is to determine the scope of the rights conferred by the patent, which must be ascertained through the construction of the claims. For this purpose, the claim is read in the light of the description contained in the specification. In short, identification of the trespass needs identification of the border, and claims are your borders. So that's why I said the drafting of the claim, you have to think a lot when you are drafting a claim, when you are filing the patent application about your own claims. Claims are your borders. In the borders, if somebody is trespassing, how to stop it, how he will trespass. All these things have to be thought at the day one when you are filing the application. So in this judgment, specifically High Court Delhi has held that the scope of the patent depends upon the nature of the claims made and enabling disclosure specified by the patentee in the patent specification. So the scope of the claim is particularly considered. Supreme Court in Vishwanath Prasad Radheshyam versus Hindustan Metal Industries AIR 1982, Supreme Court 1444, has relied on the English case law to hold that the proper way to construe a specification is not to read the claims first and then see what the full description of the invention is, but first read the description of the invention and to prepare the mind to what the invention is. So the description is also important, not the claims, not only because claims only define, description describes and make you understand. So the courts have gone to the analysis. See, when 1982, we say that we have no robust system. Court in 1982 has analyzed our own patent law, how to interpret the claims. So those who are going in the market and saying, no, there is no enforceability of the patent, it's wrong. Then next, a patent specification must be given a purposive construction. Now, if I tell you how it is, I want to claim an arm of JCB, for an example, and a holder which can do the work. I explained it is extending from left side, and somebody does it from the right side. And he says, oh, his extension of the JCB arm is from the left side. Mine is from the right side, so I'm not infringing. See the claims, see the description, and see what I'm doing. Typical defense. The court said no. The court said, we understand it better, don't teach us. We are giving a purposive construction for what he has claimed. He says that there has to be an arm. Though he has specified that in this case, this is coming out from left side, it is definitely obvious for the engineer that it can come out from the right side also. So don't give us this moonshine defenses. That is what this court has held. In Hoffman Law Roche versus Cipla, the High Court at Delhi observed that there may be certain cases where the alleged infringing product does not completely correspond to what has been claimed in the patented invention. The court recognized that the product may seem to be substantially containing the patented product, but also contain some other parts of the variants. The court held that in these cases, infringement can be found by applying rule of purposive construction. I just gave the example of it. In the year 2008, I had an occasion to argue something called as doctrine of equivalence. This is a very important concept in the interpretation and construction of a particular claim of a particular inventor. In this case, what I argued is, if two things, as I argued, you can see this, Mr. Kirpekar submitted that while considering the question of infringement of patents, the court ought to apply the doctrine of equivalence by which a device is said to infringe a claim if it is performing substantially the same function, substantially the same way to obtain the same result. This was my argument because the locks for which I was arguing were look-wise different but doing the same function. So I said it still falls within the definition of my patented claim because they are performing the same function in the same way, however they are different in look. The court accepted this contention. If you see, I am inclined to accept plaintiff's claim that the two products work function on the same principle, compression and decompression in expansion. So these are the principles behind interpretation of your claims, which we argue day in, day out in the court. Now, how to defend a suit? This also is an angle. You always cannot think from the perspective of a patentee as a lawyer. The defendants can argue that the claimant is not entitled to sue for infringement due to reasons of such defective title. He has no title. All grounds available to challenge the validity of the patent are available as a grounds of defending an action, infringement action. And now, sir, you have raised that query. We are coming to that particular aspect. This is called as a Gillette defense. This is taken by the Gillette first. Indian courts recognize the Gillette defense as a valid defense in an infringement action. The defendant can prove that the act complained of was merely what was disclosed in a prior publication without any substantial or patentable variation made. Therefore, either the defendant does not infringe or the valid patent if the patent covers prior art. I'll tell you, I had an occasion to argue this for a pharmaceutical generic drug manufacturer against a pharmaceutical giant. The patented invention was pertaining to a cream called as nadifloxacin cream, 1% cream for acne treatment, manufactured by a particular drug manufacturer. We fought that particular on basis of a generic drug manufacturer and said that what we are manufacturing is something which is covered by a Japanese patent which was published in the year 1981. So it has, after lapse of 20 years, it has come into the public domain. So it is in a generic field, we are entitled to manufacture it. That's why we are not infringing. The Supreme Court accepted it and restricted the claim in such manner. If you see, there was an injunction running against us, granted by the Honorable High Court at Madras. And if you see the third para, Pending disposal of the appeal, the order of injunction granted by the High Court is modified and confined to the manufacture of nadifloxacin cream 1%. So what has happened? They have injuncted us, but they have injuncted us only for the purposes of 1% nadifloxacin cream and not for manufacturing nadifloxacin per se. We said you are entitled to claim only for 1% nadifloxacin cream. We are manufacturing only nadifloxacin because we are bulk drug generic manufacturer, which the Supreme Court said because I could cite the patent granted in favor of Otsuka, Japanese company, which was in the year 1981, and the composition was 5-benzo-8-IJ-benzophenylazine, which is a racemic mixture, dextrorotatory, levorotatory. I also didn't understand, Supreme Court also didn't understand this, so it was vacated. This is the way it is. Sometimes just kidding. So I'm just kidding over here. But this is something which was the composition. So it was very difficult to pronounce in the Supreme Court when we were arguing. I'm just doing fun. Nothing is serious about it. So this is the case of Gillette defense, wherein we have successfully defended a case for a generic drug manufacturer saying that, look, what we are manufacturing is not covered with the patent. Though the patent covers it, that particular portion of it was already in public domain because of earlier filed patent having been come into the public domain after 20 years. This is the difference. Bowler exemptions. India recognizes the concept of bowler exemption and borrows from bowler provisions of under United States law. Under Section 107A of the Patents Act 1970, the act of making, constructing, using, selling or importing a patented invention solely for uses related to development and submission of information required under any law in force in India will not amount to infringement. So, when the product or process is used for the purposes further research and development and also for obtaining regulatory approvals in India, even during the period when the patent is in force, it does not amount to infringement. When you are doing research and development and then you are applying to the regulatory authority for permissions, but not actually manufacturing the product or using the product, that is perfectly permissible within the law. It is important provision and must be utilized for getting ready within time. When you are a generic drug manufacturer or you are a company which is working on off-patented products, then in that case, these dates are very important for you. This particular patent is coming into public domain on this day. I will start my approvals, drug regulatory approvals 3 years before. So by the time it comes into the public domain, I am ready with the package. Important patent strategy. More important in generic drug manufacturing industry. Then parallel imports. If the particular product is allowed to be sold to an authorized dealer or under any law, and I import it, then it is perfectly permissible because it is a parallel import. Already authorized person has sold it to me. You can raise that defense. Innocent infringement is always a defense for damages, not for injunction. Experimental use. Any use for solely for the purposes of experimentation and carrying on a research does not amount to infringement. That is very important for any institution because you are using it for the purposes of experimentation, further development. Invalidation of a patent can be done on any of these grounds. And I'm not getting to all this, they are hyper technical, we are almost running out of time. But most easiest thing that I have cited now is somebody else has already patented it prior to you. That's why you have to do research when it comes to even for any patent infringement case which comes to us. What we do first is, oh, somebody else has done it or not previously. Why? Because that's the best defense that is available for me. Somebody else has already done it, so I am doing it. That particular technology is not covered under this particular patent. Simple. And this is also a ground for invalidation of a patent. So I can challenge the patent on the basis of this ground. So all those grounds I have enumerated here, but they require little more in-depth analysis for you people to understand. One thing that is there, if somebody tries to invalidate your patent, in the process, not only the controller, but even during the trial of particular suit, if the court comes to the conclusion, okay, you are out of your 10 claims, 4 claims are not patentable, but 6 remaining claims are patentable, the court can direct the patent office, remove these 4 claims from the patented in this patent, and allow him to amend the specification and allow him to have the claim over 6 only. This is also possible during the litigation process. Yes, there can be a ground on the basis of which the patent is deemed unenforceable, and one of the thing is you are not working, because even if you have a patent and you are not working that patented invention, the court may say that no harm will be caused to you. Since you yourself is not working that patent, why are you enforcing it? So it is very important for every patentee that he has to submit Form 27 every year to show that he has actually worked that patent in India. It's a very important ground for denial of your relief. Then who can sue? Patent holder can sue. His exclusive licensee can sue. Non-exclusive licensee can send notice saying that you are infringing somebody's patent. But distributor cannot sue. Very important. When you are suing, you should know whether I am entitled to sue. Who can be sued? Everybody who is not a licensee, who is not doing it in the permissive capacity. He is somebody who is infringing, and you have right to sue him. Enforcement options. You have only right to go for the civil suit, as I said. The civil suit, now termed as a commercial suit. Then there is a border measure, and you can also send him the cease and desist notice saying that you should not, otherwise I will sue you. And many times it is seen that when you send the notice, they stop. So it saves you from the cost of litigation. Is it compulsory to provide notice? No. Answer to this is no. If somebody sends you a notice that you are infringing my patent and you know that you are not infringing his patent, you can also sue that patentee saying that you are issuing groundless threats under section 106 of the Patent Act. So that provision is also made by the legislature. The court procedure is, I am just trying to give you the outline so that you will understand if I have to file for a suit, what will happen to my suit. Patent infringement proceedings take the form of civil suit instituted at the civil court or commercial court. You have to file the documents at the inception. Patent, all your research work, everything you have to file in the form of affidavits. You should also file the witness evidence, witness affidavits. Examination in chief of these people will have to be done afterwards. Expert evidence under section 115 of the Patents Act is required, so that not only you are saying he is infringing, some authority like IIT or some institution, if you file that particular affidavit of person who is independent, then the court gives weightage to that particular evidence and court grants you the reliefs at the inception of the suit. That is very important. What are the reliefs that are claimed, that you can claim is at the interim you can claim a preliminary injunction wherein you can seek stay during the pendency of the suit, and the final you can not only say that he should be permanently stayed, but also during the pendency of the patent, but also grant me the damages for the losses that have been caused. So these are the reliefs which you can seek in a patent infringement suit. What I am doing is, since the timing is little bit constrained and you all are exhausted, I am sharing these slides because they are quite exhaustive on the timetable. But only thing that you must go through this timetable now, which is due to Commercial Division and Commercial Appellate Division 2015. 120 days is the maximum period from the date of issuance of summons to the defendant, in which he will have to file the return statement. And thereafter, the process starts. It ends in a specified time manner, because every time the court will give a management hearing, they will direct you, they will ask you as a lawyer how much time you will take for cross-examination, how many witnesses. So it's a very speedy trial that is happening nowadays for these kind of matters, especially in metros. As I said, preliminary reliefs and final reliefs you are entitled to. And see, the level of proofs will depend upon case-to-case basis. So this is quite exhaustive that we have made for lawyers. I'll not trouble you with this. I'll just say that one thing at the last is, it's wonderful to have a invention. It may be cumbersome to go through a patent procedure. Many a times it takes time. Still, we have to do it for the sake of one thing. That is, enforcement of patents is something which was not happening to the level which we wanted it to happen, but now it is happening. Secondly, we have to protect our own inventions. We have to show to the world at large that we are research-oriented community now. And most importantly, the government of India is taking tremendous pain now to systematically reduce the time gaps in the patenting procedure. They are making it much more simpler for you, so that you will get a faster patents, especially in the field of startups, especially in the field of MSMEs. If you register you as a startup, the time prescribed is much more lesser as compared to others. All you researchers, all I am saying is, please first go file your patent, then think about publishing. There is a system which protects you. There is a system which gives you the value for your invention. And don't think too much into technicalities, but initial homework for any research is very much important. Others can be taken care by the appropriate offices. Thank you for this patient hearing. I am sure this was exhaustive for me also, but it was thorough enjoyment for me to come back to this institution, premier institution, and whatever I could share within the given time span, I have done that effort. I know you, nobody over here is a lawyer except me and my colleague. So this session, second session, enforcement, was just to enlighten your mind, so that you should be aware of what happens. It should not that I got a certificate, I don't know what to do. That's something which bothers many a time. So you should be aware of it, what is there. That's why I given an introductory summary of what is there in the court of law. Thank you for being patient, and thank you, sir, for giving opportunity. Thank you to entire WIT as well as the entire institution. I always owe many things like this. Thank you.
I request to have a seat, and I think you have not taken a tea. So we'll ask for that. Before going to the feedbacks, if some questions are there, one or two on this particular session, we can have. Please feel free to ask.
Only one thing that I want to say is, I have these slides. I will not. I'll share with you all these slides.
I will share these slides with all the participants,
so that whatever we couldn't cover, we can at least go through. And any questions pertaining to them, you can definitely ask. Time constraints do not allow me to do each and every nitty-gritty of it.
My one question on this session:
Mm-hmm.
how Indian economy is influenced due to having patents and not having patents?
For economy, I'll say one thing is, let's take a case of economies who protect their inventors, and let's take a case of economies who do not. You see the difference. We say हाथ कंगन को आरसी क्या. हाथ कंगन को आरसी क्या means what? If economies like United States, Europe, those are developed economies, and at least as far as Britain is concerned, Britain has a system of protecting patents at least since 14th century. You will find all that history on the Patent Office website. Their industrial development in 16th, 17th century or 15th century onwards, because of the patent regime that they are following, has allowed them to rule entire world because they were always having technical advantage, technological advantage over others. This history of 600, 700 years, what they teach us, what that history teaches us, it teaches us the specific thing that a country which do not recognize this, the brain, the creativity, the innovation, will never be able to be a strong country, will never be able to be a country which can stand on its own. Today we are in the field of in the pandemic. We have seen what we could do just because we had institutions who can manufacture the vaccines. And just consider you are from a country where you do not have your own manufacturing system for vaccine or factories. Think about this. We have developed in last 50, 70 years, we have developed as a research-oriented country. Only problem is, as there is something which is similar to the third world countries everywhere, is red tapeism. And now, in last 15, 20 years, we are seeing the constant effort being made by the central government as well as the persons who are involved in this field to minimize the difficulties, minimize the red tapeism, to fasten the whole thing. And that is actually getting into the zone where we are getting results. So whatever the efforts that have been done by my predecessors who are in this field to introduce patent system in India, and what we have done in last 20 years is that we have at least sensitized the judges about this issue. The new crop of judges who are coming and joining, they are fully aware about these IP rights. They are more than happy to protect your rights, which was not a case 10, 15 years before. And this, we can't blame them because they have never done that earlier. But today the systems are there in place. Today we can say that, oh, I'll sue you for patent infringement and I'll get an order on a first hearing, second hearing or third hearing, not more. That's something which is really motivating us to say that yes, we are at par with the world. That's why I started in the morning. We have a system. So the economy will benefit out of research and development. No economy can survive now without this particular aspect, that I will protect my scientists, I will protect my technological development, and I will not only protect, I will give them incentives for it. We, as a research and technology team, because I consider myself as a team because I am there to protect it, are at the helm of the particular term called India ANSI. That's all.